Good morning, everyone, and welcome to the Senate Committee on Commerce and Labor for the 81st legislative session. Before we begin, please be sure to mute your microphone when you're not speaking to minimize the background noise. Madam Secretary, please call the roll.
Senator Hardy?
Here.
Senator Lang?
Here.
Senator Neal?
Here.
Senator Pickard?
Here.
Senator Scheibel?
Here.
Senator Settlemeyer?
Here.
Chair Spearman?
Here. Thank you. Record reflects that we have all members present and accounted for. We want to welcome our audience joining us remotely and anyone listening over the internet. Today, we have a work session on the Senate Bill 55. I would like to take a moment to go over some basic housekeeping items. As you know, the legislative building is currently closed as a public safety measure to reduce the spread and infection rate of COVID-19 to the public, and so all committee meetings will be held virtually, meaning committee members, staff, and everyone else will participate either through Zoom, video conferencing, or by telephone. However, there are various ways members of the public can engage with us and participate throughout the process. As in previous sessions, all committee-related information is available on Nellis, which is accessible from the legislature's website. There are 4 ways to engage with the committee. These include registering to participate in a committee meeting through the new system on Nellis, which places you in line to testify on a bill or provide public comment during the meeting. You may also submit written comment to the committee email address or fax number as listed on the agenda. You can also share your opinion via the legislature's opinion application on Nellis, or you may view committee meetings online through Nellis or on the legislature's YouTube channel. During the 2021 legislative session, to testify on a bill or provide public comment, members of the public must first register for the meeting and the meeting you would like to participate in. Committee meetings are listed in several places on Nellis, and to register, simply click the Participate button near the meeting date and time. Then fill in the required information such as your name, the agenda item that you're interested in, and position on the bill. Once your registration is submitted, you will see a confirmation screen, and you will also receive an email with the phone number and meeting ID to call at the time of the meeting. Just a note that while meeting registration is required to participate, it does not guarantee that everyone will be able to speak. Similarly to previous sessions, comment and public comment may be limited due to time constraints. And I'll announce the time frame, how many minutes we have for each section before we begin. It will be helpful if you or your organization will comment to remember who comment. Remember, ditto is a good response. And when someone has already covered your points, that's quite all right. You don't have to read 3 sheets of paper, okay? This will allow more people to comment during that time frame. When you're on the phone line, please pay attention to which bill is being considered and follow the verbal prompts provided by the BPS staff so that you know which keys to press to raise your hand or unmute yourself. Staff will call on you to speak by the last 3 digits of your phone number. Detailed instructions for participating in committee meetings are also available on the Help page, which is linked on the banner at the top of every page on Nellis. If you need assistance with any of these processes, or if you would like to receive an electronic notification of the committee's agendas and minutes, please contact our committee manager at the committee email listed on the agenda. Any exhibits for the committee must be submitted in electronic format no later than 8:00 a.m. the day before to our committee manager, Terry Miller, or our committee policy analyst, Cesar Magarejo. Committee contact information may be found on the committee page in Nellis. In addition, any person proposing an amendment to a bill, in order to be heard, you must first talk to the sponsor and let them know that you want to present an amendment to their bill. I will not entertain any amendments if the bill sponsor is not aware of the amendment. The proposed amendment must be submitted in writing 24 hours prior to the meeting. Please include the bill number, a statement of intent, and your contact information. When testifying, please remember to unmute your microphone and to clearly state your name and the entity you represent at the beginning of your testimony. Speak clearly and project your voice to ensure that those who are watching remotely can hear your testimony. And this is very important. I said it even when we were not virtually. If you don't speak loudly, there are several people who are trying to listen on the computer. They will not be able to hear you. So please speak and project your voice to ensure that those who are watching remotely can hear your testimony. Please remember to turn the microphone off when you finish speaking. A reminder to all those who testify, pursuant to Nevada Revised Statutes, NRS 218E.085, it is unlawful for a person to knowingly represent facts when testifying before a legislative committee. A person who knowingly does so is guilty of a misdemeanor. The chair or any of the members may request that a testifier submit documentation supporting their testimony. To committee members, during these virtual meetings, when an agenda item is called for a vote, our committee will be using roll call to do so. When the committee secretary calls your name, please answer with a yes or no, so that there is no confusion. Also, if you have a question, please raise your hand through the Zoom application, and you'll find the raise your hand down at the bottom, and I believe it's in the participant portion of the bottom of the screen. And finally, all exhibits received prior to the meeting will be available online on Nellis. So let's begin the work session on Senate Bill 55. Mr. Margarejo, will you please walk us through the bill?
Thank you, Madam Chair. For the record, Cesar Margarejo, Committee Policy Analyst. We just have one bill on our work session today, Senate Bill 55, sponsored by Senate Committee on Commerce and Labor on behalf of the Division of Industrial Relations of the Department of Business and Industry. And this bill was heard on February 3rd, 2021. Senate Bill 55 transfers the duties of issuing a certificate of registration and regulation of employee leasing companies from the Administrator of the Division of Industrial Relations to the Commissioner of the Division of Insurance, both from the Department of Business and Industry. There are some amendments proposed by Shannon Chambers, Labor Commissioner, from the Office of the Labor Commissioner, Department of Business and Industry. Her proposed amendments and explanations are attached to this work session document. The first amendment is to amend the bill to transfer the duties of supervising employee leasing companies from the Administrator of DIR to the Office of Labor Commissioner. Next is to amend the bill to change the term employee leasing company to professional employer organization, and amend the bill to change the term certificate of registration to a license, and to expand the definition of client company and professional employer organization to allow professional employer organizations to manage the labor compliance services of the client company without hiring and leasing back the client company's employees. The next amendment is to authorize the Labor Commissioner to impose an administrative penalty of $5,000 for each violation, and to change the effective date to July 1, 2021. There are some additional amendments other than what you see here in this work session document, and our committee legal counsel will provide more information on those.
Thank you. And I believe it was brought to my attention yesterday that there may be some a couple of hiccups with respect to adding people, and maybe perhaps that will add more money. If it adds money to the bill, it certainly turns into a 2/3 vote. So, Mr. Keene, will you please talk to us about what that means, please? And I would ask that the Labor Commissioner come up, or anyone else who may have an answer to this question. If you'll just stand by, and once he finishes, you can respond. Thank you so much.
Thank you, Chair Spearman. Yes, the the Labor Commissioner did an excellent job of putting together this proposed amendment. This is one of those kind of amendments that appears more complicated than it is. Essentially, what is happening is the entire subhead regarding employee leasing companies in 616B is going to be moved to Chapter 611. And along with that, there's a substantive change of changing the entity responsible for supervising employee leasing companies. It's going to be changed from the division DIR and the administrator of DIR. It's going to be changed to the Labor Commissioner. There's also going to be two non-substantive changes, which make the amendment look confusing, but it's really not. We changed the name employee leasing company to professional employer organization, and we changed the name certificate of registration to license, but those are non-substantive changes. And then as far as substantive changes go, other than the fact that the Labor Commissioner will now be supervising this process instead of DIR, the more substantive change you can find on the Labor Commissioner's proposed amendment. It's on page 2. The page will have the number 2 at the bottom. It's page 2 of the proposed amendment. The definition of professional employer organization is being expanded. And I discussed this with the Legislative Council and with the Labor Commissioner. I certainly don't want to put words in the Labor Commissioner's mouth, but it's my understanding that the Labor Commissioner is updating this definition because in practice, in more modern times, these companies generally do not actually lease the employees back. They don't hire and lease them back, but they still provide all those same services. And so the Labor Commissioner told me that this definition is being updated to reflect modern practices. From a legal point of view, though, as I discussed with the Legislative Council, on its face, it appears that we are expanding the scope of what a professional employer organization is. And because of that, at least on its face, it appears that there would be entities or potentially entities out there who currently do not need to be registered, who will have to be licensed. I don't want, like I said, I would prefer the Labor Commissioner comment on the actual real world implications of this. It's my understanding there aren't any companies that fall into that category, but from LCB Legal's point of view, we have to put a 2/3 vote on it because, at least on its face, it appears that there will be people who previously did not have to be registered, who now have to be licensed, and being licensed not only has whatever cost it takes to apply for, but there's also a $500 fee every year, which is a fee, and so that's why we would have the 2/3 vote. And the other changes, other than this, some of them have some minor substantive effect, but for the most part, they just facilitate the movement of these sections from Chapter 616B to Chapter 611, and I'm happy to answer any questions about that. Thank you, Chair Spearman.
So let's have the Labor Commissioner comment on that and maybe clarify so we make sure that what we think we're voting on, we are indeed voting on.
Chairwoman Spearman, members of the committee, thank you very much. For the record, Shannon Chambers, Nevada Labor Commissioner, and thank you for the opportunity to comment on this proposed amendment. And to your point, Chairwoman Spearman, this was a friendly amendment. It's a pretty big amendment, but it is friendly. And I will tell you that I did reach out to the industry. So it's the National Association of Professional Employer Organizations. I've reached out to the chambers, to Associated General Contractors, Nevada Contractors Association. So to understand kind of the origins of why we're here today. So the term professional employer organization has been used by the industry for over 20 plus years. Even going back to the legislative history, the Nevada Legislature knew that that was the terminology going back to 2009. So this is really bringing the statutes and the language up to 2021 standards. It is not the intent of the Labor Commissioner with this amendment to create new fees or to make these companies get relicensed or apply for a new license. based on my conversation with the professional association, these companies have not been leasing employees for over 20 plus years. What they're actually doing is providing payroll and human resources kind of consultation and labor compliance services. So the intent would be we would capture these companies in the renewal period. So they would be renewing anyway, and they would have to go through that process anyway, but it is not the intent of the labor commissioner to create a new fee or to make these companies go through a new process to get a new license. It's essentially just ensuring that they are now under the proper terminology in the industry, and that upon a renewal, their license would reflect professional employer organization. So I'm happy to answer any questions.
Thank you, Ms. Chambers. Any questions from committee members?
Madam Chair.
I think I heard someone. Senator Pickard?
Senator Hardy was talking, and then I had a question too, Madam Chair.
Okay.
Senator,
Senator Hardy, you got to speak up a little louder. Senator Hardy?
With your permission, thank you, Madam Chair. So with this change, the shift from one to the other, is it budget neutral, or is there something else that we're aware of that is going to increase the cost or the fee?
So again, thank you for the question, Senator Hardy. Again, Shannon Chambers, Nevada Labor Commissioner, for the record, and Chairwoman Spearman, with permission, I'll go directly to Senator Hardy.
Yes,
so
please
there
do.
is the transfer of revenue from the license fees, Senator Hardy, but there are no new fees. The license fee and the renewal fee would stay exactly the same. The Labor Commissioner is not asking for any new positions, so it would simply be the transfer of that revenue from the license fees and renewal to the Labor Commissioner, but no new fees at all.
So it's budget neutral, and it's just a shifting of where the money goes, or is it the money doesn't go anywhere? It just stays in insurance and doesn't go to labor.
So again, Shannon Chambers, for the record, Nevada Labor Commissioner, my understanding would be that the money would go to the Labor Commissioner, but it would still be budget neutral.
Thank you.
Thank you. I think Senator Pickard, were you next, or Settlemyre?
I
Senator Settlemyre?
have no problem deferring to Senator Settlemyre.
Okay, Senator Settlemyre?
thank you, Senator Pickard. I appreciate that. I had two questions. The first one really went to amendment number 3, amending the bill to change the term certificate of registration to license. Why are we necessarily doing that? I mean, a certificate is quite different than a licensure. So I was just curious why the desire to change the terminologies and what that implications does that mean?
So again, Shannon Chambers, Nevada Labor Commissioner, for the record. The term license, Senator Settlemyre, is typically what is used in the other states for these organizations. Again, if there was concern about that, I did talk to, like I said, the National Association of Professional Employer Organizations. They were supportive of the term license. They would still have all the due process associated with that, which they already have with the certificate, but they would have a right to appeal a denial or a revocation. But they thought it reflected more accurately what is going on in the other states and actually what's going on in the industry.
Okay, I appreciate that. My second question, then I have a comment, if that's okay with you, Madam Chair, is number 5, the authorization of the Labor Commission to impose an administrative penalty of, I assume, up to $5,000. So in other words, it's not guaranteed that every violation is $5,000. I would hope that there's a staggered concept that if it's a minor violation, or are you saying it's a flat fee of $5,000 for each violation? Did that already exist in the other department and you're just transferring said authority, or is that something new?
So again, Shannon Chambers, Nevada Labor Commissioner, for the record. So it is new in terms of professional employer organizations. it would not be a maximum and an automatic 5,000, Senator Settlemyre. It would be a sliding scale, and the Labor Commissioner would have discretion on that. That's typically consistent with the authority that the Labor Commissioner already has under Nevada labor laws. It's up to 5,000. Again, there would be a right to appeal any penalty that was imposed, but it would not be an automatic 5,000. And again, this, in my opinion, as the Labor Commissioner, is a better way to regulate an industry like this, because the existing language requires the filing of a lawsuit and then potential damages and actually bigger penalties for these companies right now. So this would be more consistent with the penalty structure of the Labor Commissioner as it exists in statute right now.
Okay, but you do have the authority to do 5,000 other organizations or other sections that previously existed that are being transferred? And if so, how many times have you actually ever given that level of a fine, just out of curiosity?
So again, Shannon Chambers for the record, Nevada Labor Commissioner. So, I mean, this is a new enforcement area for us, but under my labor authority, under Nevada Revised Statute Section 608, we do impose $5,000 penalties quite often if the actions of an employer are intentional. That's typically what we look to. It's not an automatic, but there have been situations where we do impose a $5,000 penalty if we view the actions as intentional.
Okay. With that, Madam Chair, I understand the bill. I'm apprehensive about the violation because this is the first time, $5,000 violation, the first time we've seen that. So I'm going to try to reach out in the meantime after we process this, Madam Chair, and talk to professional employer organizations and see what their thoughts are. Because again, this is the first time I've ever heard of it in this respect. And with that, I just want to make sure that we're transferring it to the right entity, because when we started out, it was going one place, and then during the testimony, it went to another place. And I just want to make sure we don't go yet another place. So hopefully this is the right place to have this situated. So with that, thank you for allowing me the indulgence of the questions, Madam Chair. I'll let the next person go.
Madam Chair, if I may clarify.
Thank you. Senator Pickard. Oh, I'm sorry. Someone's getting ready to say. Is that you, Mr. King?
Yes, thank you, Chair
Okay.
Spearman. Just a quick point on the administrative penalties. I absolutely agree with the Labor Commissioner. The $5,000 penalty is in line with the other existing penalties that she has in different areas, including in particular in Chapter 611. 611 already regulates private employment agencies, and they have that same $5,000 fine, and it's an up to. So it's not absolutely 5,000. It's up to 5,000. But it's worth also saying that where these sections are now in Chapter 616B, they're all enforced by DIR through DIR's rather robust investigation and fine structure. And in fact, the fines are currently set forth for these provisions in NRS 616D.120, and they have a more complicated fine structure, as you can imagine, for workers' comp. But essentially, for intentional violations right now, an employee leasing company would have a fine of minimum of $1,500 for their initial violation and $15,000 for second and subsequent violations. For unintentional violations, they would get a cease and desist letter, and then after that, penalties of $375 to $3,000. So it's a more complicated structure right now, and they'd be moving over to Labor Commissioner's up to $5,000 penalty. Thank you, Madam Chair.
Thank you for that explanation. Senator Settlemyre, did he answer your question or address your concerns?
He answered yes, he gave me some information about the concerns. But like I said, this is the first time I've seen this penalty, in this amendment that's come forward. And I am going to try to reach out to some of those entities that she said she had talked to, AGC and so forth, in order to try to hear back. So I'm apprehensive about that concept because, again, it's brand new. It just was, came up with an amendment, and I appreciate it. I should have done my homework last night so I could have reached out to him before, but sadly I did not. And therefore, I'm apprehensive about it. But thank you, Madam Chair. I'll let the next person in line go. Thank you.
Thank you. And I think if you need more legal clarification, then certainly Will can help you with that. So you all can talk about it offline. We've got Senator Pickard up now, and then Vice Chair Neal.
Thank you, Madam Chair. I'm going to circle back to the topic of licensure in just a second, but I wanted to first make sure that is the issue of the financial review, which I understood to be the genesis of this whole process, of this whole purpose of removal, that's still going to be done by a third party, or is the Department of Labor going to take that on?
So thank you for the question, Senator Pickard. This is Shannon Chambers, again, Nevada Labor Commissioner for the record. So after the previous hearing on this bill, I had discussions with the Commissioner of Insurance and the Administrator of the Division of Industrial Relations, and also again with the industry and the association, the National Association of Professional Employer Organizations, to understand what that review actually entails. And I am comfortable that the Labor Commissioner can do that review. We already do that review for private employment agencies. I think we just needed to get that clear between all of us, but we will do that review. So there will not be a third party that does that.
Great. All right. That explains why I didn't see it in the amendment. Thank you for that. I want to circle back, though, to the difference in licensure, just as a backdrop. One of the things that Chair Spearman has pushed in the Sunset Subcommittee, for example, is to ease the barriers to entry to various employment opportunities, and to reduce, ultimately, as part of that, to reduce the licensing requirements. I've looked at NRS 611 and 616B. These organizations only had to register before. They did not have to meet any requirement or testing or pre-qualification for licensure. There's no statutory scheme for licensure. And even though other states may call it a license, we don't. There's nothing in our statutory scheme, and our statutory scheme across the entire statutes make a distinction between registration and licensure. And there's nothing in the regulations or the statute that are prepared to handle a licensure. So arguably, and this amendment doesn't address any grandfathering or any period of time that the license or the registration would would survive the effective date of the legislation. So all of a sudden, all these individuals or all these entities are out of compliance. They're not licensed unless we get through this, and we have to promulgate the regulations. So I mean, I guess this is really a question for Mr. Keene. When you said this was a non-substantive change, wouldn't you agree that changing from under a Nevada regulatory scheme, changing from a registration to a license is indeed a substantive change?
Chair Spearman, with your permission.
Yes, please, Will.
Thank you. No, Senator Pickard, there's no substantive change here. It's purely a name change. There's no substantive difference between this license and this certificate of registration. It's purely a name change. All the requirements are exactly the same.
Okay, and so we're going to use the term license in a new way in our statutory scheme. I'm concerned about ambiguities that will arise and whether or not this then opens the door to licensing, even though the requirements arguably aren't changing. We're using a word in this. Well, can you point to another regulatory body that uses the term licensure for what in this case has been called a registration?
Yeah, can I just jump in? And I think what Mr. Keene said is that in his opinion, an LCB is the one that's the last arbiter when we have questions, that there's no substantive change. And if there were a question about it, we can always, like we do with any bill that's already passed, anything that's in statute, we can always go to LCB and get the legislative intent clarified. Okay. I want to move on. I hear what you're saying, but he's already said that there's really no difference. So I don't want to get into semantics.
I appreciate that. I just want to make sure we have a clear record, because the courts have to establish.
Senator Pickard. Senator Pickard, we have a clear record, okay? We have a clear record. I've got a couple other people that want to testify, and I want to make sure that we have time for our public comment after the bill closes. So he's already said there's no substantive change. Already said that answered your question, and I think he's answered sort of Suttermore's question. If there's something else that you need to understand from a semantics point of view, then please feel free to contact him. LCB is the final arbiter for any questions we have for statutes or BDRs or bills, what have you. So they are the final arbiter, and he's already spoken. Okay?
Well, I
Madam Chair.
respectfully disagree.
Just a minute. Hold on. Okay, Senator Hardy, your hand was up.
Thank you, Madam Chair. It was a simple question. You know, we're not making a substantive change. We're making a shift from one.
Senator Hardy, can you get closer to the mic, please?
Yes. So we're making a non-substantive change. We're shifting from one entity to the other. We're putting in a fine that is different than the other fine schedule. So my question would be, how many and what did we actually have a history of fining before under the Division of Insurance versus this up to $5,000? So in other words, are we doing more fining, or are we doing less fining, or did we even do any fining? And if we did fining before, was it less than $5,000? And if it was, then we haven't actually increased a fine. So I mean, it sounds, petty maybe, but what did we fine before? And is it less than $5,000?
Madam Chair, I think I can answer that question.
Go ahead.
Yes, please. And after you do, I'd like for Mr. King to step in because I don't want to be redundant with the questions. Some of the things he's already answered. So if you'll step in after the Labor Commissioner and make sure that we've got whatever we need from a legal standpoint, we've got that, and it clarifies in everyone's mind. And if not, there's always the opportunity to go to either LCB or go to the Labor Commissioner or whomever after this. You can always, when you vote, there's something that we do when we vote that will allow you to change your mind. And that is this phrase: I reserve my right to change my mind on the floor. I really have to make sure that the questions that we're asking have already been answered. And if not, if there's a peculiarity about it, then I would really suggest that you go to LCB or the Labor Commissioner. But for me, I'm satisfied that he answered the question about $5,000, but he can take it next. And after you, Senator Hardy, I'm going to Vice Chair Neal.
Madam Chair, this is Victoria Carrion, the Administrator at the Division of Industrial Relations. Since we currently have this function, I wanted to clarify that we have not done any fines on any employee leasing companies. And in fact, when there is an issue, we have referred it to the Attorney General's office. Thank you.
Will?
Thank you, Chair Spearman. Just to repeat on the fine issue, the fine provision, it does appear as new language, and it's new in the sense, well, what I would like to just do a comparison. Currently, under the current statutes, the penalties that would apply to an employee leasing company are just set forth in a different section. The way that the workers' comp statutes are organized into chapters 616A through 616D, they have a chapter 616D which handles things like enforcement, investigations, fines, and that's where those statutes are located. So you don't see them in the same subhead with the employee leasing company statutes. However, those fines still apply, and as I mentioned, the DAR has a slightly more complicated fine structure, which is that it depends on whether the violation was intentional or unintentional. If it's intentional, like I said, the intentional fines range from $1,500 per violation to $15,000 per violation, and the unintentional range from first a notice, which has no fine, and then a range of $375 to $3,000. The Labor Commissioner, instead of, so in place of that existing scheme that would apply, because right now the employee leasing companies are regulated by DIR, in place of that, the Labor Commissioner has put in a $5,000 penalty, which does not differentiate between intentional and unintentional, at least not on its face. But the $5,000 is a cap, and I wouldn't want to speak for the Labor Commissioner, but I believe that she said that they take into account whether it's intentional or unintentional when they decide how much the fine would be. And it's important to point out that under the current scheme under DIR and under the Labor Commissioner scheme, anybody who's aggrieved by any kind of penalty can always appeal that to court. And that answers that question, I believe, on the fines, although I'm happy to go into it a bit more. And as far as the licensing versus registration, I just want to point out that I know that we're not in Title 54 right now with all the professions, but Title 54 is where most of the professions are located. And for the most part, there are licenses. Sometimes there are registrations. And just to be really blunt about it, the requirements for each license or registration, whatever it's called, are simply the requirements that are set forth in statute for that license or registration. Ultimately, it doesn't matter whether it's called a registration or called a license. However, generally, it's the practice that when it's more difficult to obtain the license, that we call it a license, and when it's simpler and more basic, we call it a registration. But that I think goes with perhaps the public conception of what these things are, that registration is easier to obtain, but that's not legally necessary, which is why I said this change is a non-substantive change, because we're not changing any of the requirements for getting this registration or licensure. And as far as the transition, LCB Legal will be putting in a transitory provision saying that upon the effective date of this bill, or something to this effect, upon the effective date of this bill, the existing registrations will be new licenses, and upon the next re-registration or renewal, then they will be called licenses. So from the point of view of the registrants / licensees, this will be seamless. There'll be a different word on their certificate. Thank you, Chair Spearman.
Thank you. Vice Chair Neal?
Thank you, Chair Spearman. I wanted to ask, two questions. One to Ms. Carrion. I think Mr. Keene really spelled it out, but I just wanted to know for Ms. Carrion, for the AG and how you send it to the AG, what are the fines? Are there fines administered through the AG?
This is Victoria Carrion for the record. Thank you for the question. I'm not sure if there were fines issued through the Attorney General's office, but the Division of Industrial Relations has not issued any fines for the employee leasing companies.
Okay, great. Thank you for that. And then my second question is to Ms. Chambers on the PEO. So Ms. Chambers, my only I guess issue or concern is for the PEO, since you said it's been the standard definition for 20 years, does this broaden the place for your regulatory authority in regards to, will you need more expertise by taking on that broad language, or is it the exact expertise that you need for the switch that we anticipated at the beginning of the hearing?
So again, Chairwoman Spearman, Shannon Chambers, Nevada Labor Commissioner, for the record, through you to Vice Chair Neal. So in terms of the term professional employer organizations and the expertise of the Labor Commissioner, Vice Chair Neal, this fits squarely within the expertise and regulatory authority of the Labor Commissioner. And to your point that this terminology and these entities have been around for 20 plus years, the Nevada Legislature and the different industry organizations and associations have been trying to figure out where these belong best. And it is my opinion, and in conversations, like I said, with the professional association, with the Associated General Contractors, the chambers, and reaching out, that these belong with the Labor Commissioner, and we have the expertise to do this.
Okay, thank you.
Thank you. Senator Hardy, is your hand up or you just didn't put it down?
Thank you, Madam Chair, for recognizing me a second time.
If you would speak a little closer to the mic.
The way I look at this is there's an issue that maybe we haven't resolved offline. So I recognize the issue, and I quite frankly could go either way and make sure that I reserve a right to change depending on, where we go with this. I appreciate Mr. Keen's evaluation, and it was kind of enlightening because in different places, like in the cosmetology board, we're looking at registration versus licensing, and apparently there's no real difference from a practical standpoint. So I appreciate the education. I appreciate the fact that we haven't had any fines by the insurance division, as it were, but I don't know what the AG's office has done. So in essence, there probably have been some kind of fine done through the AG's office, but I don't know that. So there are some unresolved questions, but I don't think we need to get upset about what it is, because I think, we still have the floor vote to come. That's kind of where I'm at. Thank you.
Okay. Thank you. And my only point through this is I don't want to keep asking the same question 5 different ways when our legal counsel has clarified. And I will say again, if there's anything about this that you're uncomfortable with, if there's an I not dotted or a T not crossed, you can always change your vote on the floor. You can always say that. So anyone who hasn't spoken yet have a question? Okay, seeing none. I will then entertain a motion to do pass.
Chair,
Amended do pass. Amended do pass.
so moved, amended do pass.
Have a motion from Senator Scheibel. Have a second from Senator Lang. Further discussion?
Madam Chair,
Yes?
I'm still checking with individuals. At this time, I will be going no with a reservation to change to a yes upon the floor. I disagree with the concept that the LCB is final, because they are not. The Supreme Court is final, not because they're right, but because they're final. Thank you.
And I appreciate that review. However, when we're talking about laws and getting ready to pass statutes, then our LCB is the arbiter. If it does not pass muster in the other courts prior to the Supreme Court, then so be it. But when we have questions about bills and legislation, and I think we covered this last session, and Senator Settelmeyer, you were there when we got the reading from LCB, because one of the boards went outside of the legislature and asked another attorney. And we got the reading that when it comes to this, they are the final arbiter. I'm not stupid. I understand the Supreme Court. But when we're talking about bills that we're getting ready to pass, when you ask a question and LCB answers, that's it. If people don't like it, then they can take it to court, or they can keep going until the Supreme Court. Supreme Court is not here right now. And the people who write the concepts that we give them for BDRs to become bills, they are the ones who understand the statutes. They are the ones who understand the legislative intent. And so, as far as I'm concerned, Supreme Court, see ya. Anyone else? I'll take a vote. All those in favor, Madam Secretary, please call the roll. And you can always change your vote on the floor.
Senator Hardy.
I'll vote yes with reserve the right to change my vote. Thank you.
Thank you. Senator Lang.
Yes.
Senator Neal.
Yes.
Senator Pickard.
No.
Senator Scheibel.
Yes.
Senator Settelmeyer.
No for now.
Chair Spearman.
Yes, and I believe that means we have more. How many yes? How many yes?
We have 5
Madam
yes.
Secretary, how many?
We have 5
And no?
yes and 2 no, and one of the yeses reserves the right to change on the floor.
Okay, I just wanted to be clear with everyone what the final vote count was so that there would be no mistake in terms of did it pass or not, and it did pass. So this passes, and what I will do is, Senator Lang, will you take this on the floor statement, please?
Yes, ma'am.
Okay, thank you. Okie dokie, now that we have closed the hearing on Senate Bill 55, that is the only business that we had today with the exception of public comment. And so, excuse me, we will move to public comment and we'll have 20 minutes for public comment. Would like for each person that speaks, please only use your 2 minutes. If your time runs out, you can always submit your testimony. So, broadcast.
Chair, your line is currently open and working, and you have no callers at this time.
I'm going to give it a couple more minutes just to make sure somebody's not having technical difficulty. No one on the line?
Chair, no, you have no one on the line.
Okay, so we will close public comment and we will adjourn this meeting and we will be back here at 8 o'clock on Monday. 8 o'clock on Monday. Thank you all for your participation and thank you for the lively discussion. We are now adjourned.